a very serious prison sentence. You have 15 years of incarceration over your head. Are you telling the court you didn't violate that?
I didn't.
All I've heard from you, Ms. Nelson, are excuses. And so you're essentially telling me that Ms. Bebo is lying.
That's not okay.
You blatantly lied to Ms. Bebo, thinking you could get away with that. That's called criminal thinking. That's criminal thinking. You are still using that criminal thinking brain.
This defendant was originally facing up to 15 years, but now she's back in court for violating probation. And honestly, it's like she didn't even try to follow a single rule. The way she talks here is unbelievable. Every question turns into an excuse or a lie. You can literally see the judge trying to stay calm, but it's clear she's running out of patience fast. I don't know what this woman thought was going to happen when she ignored every condition of her probation. The ending of this hearing is one of the toughest sentences we've seen in a while, and honestly, it's well-deserved. Let me know in the comments. Was the judge too harsh, or was this exactly what she needed? Let's dive in.
We have Kelly Nelson appearing by video conferencing in custody in Burnett County Jail. We're set here today in this matter due to a request and a petition to amend the judgment of conviction and add some conditional jail time due to some violations that are alleged to have occurred by Ms. Nelson. This is a very serious case. The court recalls the facts very clearly as it relates to this matter. And Ms. Nelson was given a very sweet plea deal with the state to plead to possession with intent methamphetamine, over 3 grams but less than 10, a Class E felony, and she did receive probation instead of a prison sentence at that time. So Ms. Bebo, we're here due to the department's request for conditional jail.
Yes, she is objecting to the conditional jail time.
All right. So Ms. Bebo, can you please provide the information and recommendation to me, please, to the court?
Yes. So due to some methamphetamine use, possession, she refused to provide UAs while in custody during that time and refused to go to court. She did not have an active phone number when I attempted to contact her mother, who was the person that she was intended to live with, who she's reported that she lives with. And then as far as not contacting me, she stated that she does not have funds for a cell phone or for gas, food, etc. So basic needs, and that is why she did not report to my office.
Ms. Nelson, I'm now going to ask if there's anything that you would like to say to me or you would like to let me know as it relates to this matter. So I just need to make you aware that, and I'm sure Ms. Bebo made you aware that on a probation review hearing such as this, in which conditional jail is being requested and the court is being asked to modify the judgment of conviction, the court has no obligation or duty to follow the recommendation of the Department of Corrections, meaning that I do not have to order 51 days conditional jail. I could order 0 if I find that it's appropriate. I could order up to a year if I find that that's more appropriate. You have the ability and right to say what you wish to tell me. This is not like any other criminal court hearing you've had, because I can use your silence against you. So please let me know what you would like me to consider and what you are asking of the court.
Along with the Turtle Lake address, I went to my Cumberland apartment to pack it up so I could move out of it. And when I got out of jail, I didn't have the funds and things didn't go as planned, but I did not receive an appointment from Burnett County, the guards here the agent. She did not tell me a report date when I got out, so I didn't miss appointment on purpose. And when I got pulled over, I was gonna drop my kids off and come to probation, actually. That was my plan. But I got pulled over first. Yeah,
All right, so anything else?
no, I don't believe so.
So, go ahead.
The rest of all of the stipulations you gave me for completing paper, I've got through all of them and I'm in the process and will have my GED or HSCD within the next 3 weeks. Here at the jail, they have a program. So I'll have that complete as well. And yeah, I've done all the parenting classes and everything else. I just have to finish my HSCD and pay my $500 and some, I think it is. And
So you had gainful employment?
I did in March. Or before I went to jail then. And when I get out, I'm planning on going to the Butterfly House now, which therefore I will have immediate gainful employment.
The other
Yeah.
condition, another condition was no use or possession of alcohol, illegal drugs, paraphernalia, any controlled substance without a valid prescription. Are you telling the court you didn't violate that?
I didn't.
It's almost like she forgot the judge knew she used drugs while on probation. The judge gives her every chance to explain herself, but she just keeps dodging the main issue and talking about stuff that doesn't matter. The moment the judge calls her out, her face says it all, completely blank, like she's caught off guard. I'll never understand why defendants think they can talk their way out of something when the evidence is already on record. The smartest move in a situation like this is honesty. Admit the mistake. Show you're ready to change. Instead, she just avoided it and made things worse. What do you think? Did she really not care? Or did she just think she could get away with it?
2.5 years, that was good. I had a miscarriage and it slipped up, but it was a minor slip up and I was already getting sober again when it all came to surface and I regretted it ever since. And
Is that why you avoided your agent in February?
No.
Why did you avoid your agent for those 3 days?
Oh, well, I was in jail. I just had a miscarriage. I was depressed and
No, was it February 2nd, 3rd, and 4th?
That was July. So I believe what
Sorry.
she's referring to is the last conditional jail time that was ordered
Yeah.
previously.
All right, but with this July 2nd, 3rd, and 4th, when you were being asked to go meet with your agent,
I did not get a response as far as what she had said, was just that she would not provide one after being asked multiple times.
okay, why didn't you provide a sample for the corrections officer when you were in custody?
the first time was right before I gave my statement, and I still hadn't received a glass for water. I was there for 2 hours, and they were busy. And the second time, I don't know.
How about the third time?
I don't even remember being asked a second or third time, honestly.
All right. So if I am to believe the statements that you're telling me here today, are you telling me that Miss Bebo and her connections and the information provided to her are wrong and are lies?
I'm not saying she's lying, but it's not, I don't know. The address thing is not what, I don't know.
You never told her that you didn't update or give your correct address of where you're living, which is a requirement.
Yeah, and she knew
Because you didn't want to move or transfer agents?
she knew about the apartment address, and I told her I was moving back in with my mom, which I was moving back in with my mom. I just had to go pack up my apartment. That was,
Ms. Bebo, were you under that impression? Did you know that she was just going to that apartment to pack it up?
No, Judge, I was not aware that she was living in Cumberland until she was arrested and served conditional jail time the first time. And then I was again under the impression that she was being evicted and would be living with her mom upon release.
yeah. That was,
Is that accurate, Ms. Nelson?
yeah, that was my plan, was moving back in with mom.
Now, what I'm asking, if it was your plan, because your plan was wrong, and it was violating DOC policy, state law, and the court's conditions of your judgment of conviction. So all I'm hearing from you, all I've heard from you, Ms. Nelson, are excuses, why I didn't do what I was told to do, why I didn't do what I was legally supposed to do, why I didn't do what Department of Corrections requires me to do. Because I've heard excuses and the opposite of what Ms. Bebo has stated here in court. And so you're essentially telling me that Ms. Bebo is lying.
That's not, okay.
And it's hard for me to believe that the day that you were pulled over with your kids in your car, you were driving to drop them off so that you can go see probation. It's always that. I'm going to tell you, this isn't the first time I've heard this. People are always on their way to Department of Corrections to turn themselves in. They're always having an interview the next day when they're in custody, or the day of they got picked up. They're always starting a new job, and so they need to be released from custody. They're always doing what the court told them to do, but for the fact that they got picked up and they got arrested. All I heard were reasons, again, that were completely opposite than the information and facts that I was provided by Ms. Bebo. I need to state that you were given a very, very sweet plea deal, but for the fact that your attorney argued for your rehabilitation, you faced a very serious prison sentence. It's a Class E felony, That means you could face 15 years of incarceration, 10 years of initial confinement, and then the 5 years of extended supervision.
Mm-hmm.
That's hanging over your head right now.
I understand.
Defendants like this always walk into court saying they understand what they did wrong. But if they really did, they wouldn't be back in front of a judge. This woman refuses to take any real accountability. It's just excuse after excuse. And they all forget the simple point of the law. It's not about punishing perfection. It's about protecting people and learning from mistakes. Imagine how much better things would be if everyone just took responsibility instead of blaming the system. If I were in her shoes, I'd be straight up with the judge, admit I messed up, and explain how I'm going to fix it. That kind of honesty goes way further than fake apologies. Honestly, she's a perfect example of what not to do in court.
That should be a huge hammer hanging over your head, where you say, Ms. Bebo, I'm going to do everything that I need to do. I need to follow the law. I need to follow the judge's orders. I need to follow what the Department of Corrections is requiring of me.
Mm-hmm.
You were also provided the ability to reunite with your children, because during that time, I can't recall if it was Barron County, removed your children from your care. I understand relapse, and I understand it very completely with doing the treatment court. That happens.
Mm-hmm.
But there are ways that you work, in the ways that you use the tools that you've learned after a relapse, and that includes having the people that are there to help and assist you and guide you, and having those conversations. Ms. Bebo is one. Going to A is another. Based upon the information that I have here today, I do find that you have violated numerous conditions of the court on the judgment of conditions, as well as violated your rules and policies of the Department of Corrections. I'm ordering conditional jail. I'm ordering 120 days, not 51, 120 days. You have 15 years of incarceration over your head. That means no little white lies if you believe they are lies. Here they weren't little white lies. I don't believe that for a second. You blatantly lied to Ms. Bebo and to others of authority to do what you want, how you wanted to do it, thinking you could get away with that. That's called criminal thinking. That's criminal thinking. Has she been engaged in any MRT or other such programs?
She was not enrolled in any program when she got transferred to my case, no.
All right, well, I'm also going to order that. She has to do either a thinking for a change or breaking barriers, MRT, something of that nature.
Polk County just started MRT.
Okay, excellent. You are still using that criminal thinking brain. I understand the loss, a miscarriage, but a loss of a child. I completely understand that. I understand having the sorrow and the pain. I also understand reaching out to others who can keep you on that sober path and keep you on the non-criminal path. Because Ms. Nelson, it may come down to it where the department's going to next ask that you be revoked and you be sentenced with 10 years of initial confinement and 5 years of extended supervision hanging over your head. That is nothing that you should take lightly. So 120 days from date of arrest or pickup. And it appears that I'm going to have more probation review hearings with Ms. Nelson because she's not understanding the risk. If she needs the court to babysit her to make sure that she understands that risk, I will.
120 days might sound like a lot, especially when the state only asked for 51. But after seeing this case, I get it. She lied to the judge, lied to her probation officer, and refused to take any responsibility. At some point, second chances have to stop meaning endless chances. Yeah, she's had a tough life, but that doesn't excuse refusing to change. The courtroom isn't about being perfect. It's about being accountable, and she showed none of that. So even though the sentence feels harsh, I think the judge made the right call. What do you think? Was the judge fair, or did she go too far? Thanks for watching, guys. See you in the next one.